In this training module, I'm going to show you how to think more like a patent attorney. This is a break from the specification that we're drafting. We'll get back to the detailed description shortly. But I want to talk to you about balancing some of the competing interests for your patent application, and just for reference, some of the competing interests for a typical patent attorney. By the end of this training module, you should be able to begin thinking about the balance between patentability and enforceability for your own invention and patent application. Let's get started. On the screen, you'll see a simple diagram of a character trying to balance a bunch of spinning plates or something. And that's about how it feels sometimes as a patent attorney when you start thinking about all of the different things that you've got to balance. And I've introduced you to some of those already. For example, whether or not you can get a patent on your own invention, whether or not your product that you make based on your patent application could also infringe somebody else's issued patent. And again, whether or not somebody else could infringe your patent once it's issued. Those all have to be kept in mind and balanced in different ways, and we'll talk about that here in a little bit more detail. Also, for a patent attorney, there are a few other interests that have to be kept in mind. You shouldn't have to worry about this because you're drafting your own provisional patent application, but at some point in the future, if you decide to file a non-provisional patent application, you should hire, in my opinion, an experienced patent attorney who can help you with this, because there are just some things that are really hard to navigate without having had years and years of experience in the patent process. And when you do hire a patent attorney, you should also be aware of some of the competing interests that would impact his or her interests in helping you with your invention. For example, every patent attorney has to work for paying clients. That's how the business works, and so that's what they do. So there's always this balance between whether or not a client can actually pay the patent attorney's normal rates, or perhaps a discounted rate in some instances. There's also a balancing factor as to whether or not a client might create some type of malpractice liability, whether or not a client likes to sue their attorneys who work for them. And believe it or not, there are quite a few people out there like that. They often will use that as a tactic to achieve other goals. Not listed on this list are some other things like whether or not accepting one person as a client would introduce a conflict of interest with another existing client. Or some attorneys are very, very careful to not accept anybody who would create a potential conflict in the future with a perhaps larger and better, in some ways, if you want to say that, better client who could bring in a lot more money into the firm or into their paychecks. So there are a lot of different factors that people have to balance. And I'm not trying to create any implications here about attorneys or other people in the legal profession who would use these factors to make poor decisions about who they would have as a client, how they would perform for that client, or anything else like that. Let's just all admit, though, that there are a lot of people who have a negative impression of attorneys for a multitude of reasons, and these types of factors probably are some of the influencing factors that motivate attorneys to act in different ways other than what you might expect once you've hired them. With that being said, let's get back now to the balancing world of patents and the patentability and infringement aspects of patents. So anytime we talk about patents, I want you to think of the Goldilocks story. Goldilocks and the Three Bears, of course. Goldilocks enters the bear's house, finds 3 different beds, 3 different chairs, 3 different bowls of porridge, and she tries all of those things and finds that there was always something wrong with a couple of them, and the other one was just right. In the case of the food was either too hot or too cold or just right. And of course, what we want is the same thing that Goldilocks wanted. We want to find that just right fit. In an analogy here to Goldilocks, we have what is too hot, too cold, and just right compares with what is too broad, too narrow, and just right. And let me explain what that means. In terms of your invention and how you view your invention, you might be viewing your invention as very, very new when in fact it overlaps substantially with other things out there that are already in existence or have been described in patent applications. In that case, your patent application on your invention could be drafted in a way that's considered to be too broad. Too broad in the sense that it overlaps with other prior art that's already out there. To the extent that it overlaps with existing prior art, you should not be able to get a patent on that. And even if you did get a patent, you should not be able to sue somebody successfully on that because they'll probably just attack your patent and try to get it invalidated for being too broad. On the other end of the spectrum, when something's too cold, we would interpret that as being too narrow. That means that you've created an invention that fulfills a certain need in the market, But what you've done, perhaps unintentionally, is to draft a patent application or patent claims that are too narrow, meaning you haven't covered the full scope of what you're entitled to protect. Perhaps you've added limitations into your claims, or you've described just one embodiment, one example of your invention, when in reality you could have covered 4 or 5 or 6 different variations of that same invention, different types of connectors, different types of surfaces, different types of operating procedures, whatever it is that you could alter in some fashion without overlapping existing prior art, but you failed to do so, and so you have a patent that's too narrow. The impact of a patent application that's too narrow is that you are going to fail to capture infringers when they create competing products that fall just outside of your claimed invention or your described invention in your patent application, but fall well within what you were entitled to claim based on the general type of invention that you came up with. So you don't want to be too broad and potentially have a patent that's either not granted or later on invalidated. You also don't want to be too narrow in terms of having claims that are never applicable to the competing products that your competitors come out later with when they copy you and evade some of the limitations that you require that shouldn't necessarily be required. What you want to do is you want to be able to come up with just the right claim, just the right temperature of food, just the right bed, just the right chair. You want to be able to balance the potential for invalidity claims against the ability to actually get a patent on the invention that you've come up with. And that's not an easy task. We're not going to get into how you need to do that here. This is really only to help you be aware of that balance that exists in the patent world. And with your invention, I want you to think about what you came up with as your invention. It's probably one specific version of your invention. So start to think about how could you vary that? What things could you change to make it broader? And then once you've got a broader view of your invention, you probably want to take the opposite perspective and start to narrow it down a little bit and say, well, if I put that in, how does that overlap with existing technology? Is there a way that a patent examiner could say that I'm actually doing something that already exists, or part of what I'm doing already exists, and narrow it back in? And you'll need to find a balance that you're comfortable with, where you feel like you're protecting enough area or ground around your invention without trying to be too greedy about it and protect things that you're not really entitled to. That's just going to be a balancing act that I want you to strike on your own, just given what you know about your invention, about the market of it. And the more you know that, the more confident you can be in the balance that you strike. The less you know that, the less confident you'll be in the balance that you strike. And that's okay. I just want you to be able to come to a balance based on how familiar you are with your invention, the technology, and the market. And we'll go from there, because later on, one of the reasons for filing your provisional patent application in the first place is you might not know those things. So you want to give some variety of examples in your patent application so that you have some potential to protect those different levels of your invention, different breadths of your invention, different variations, so that you in fact can go out later after it's filed and patent pending and can explore and research and gather more data about what is the appropriate scope that you should be going after to balance the patentability and the potential invalidity that somebody might claim against you. So don't worry about coming to the perfect spot right now. Just be aware that there's a balance there. To the extent you don't have all that information at this point in time, you can gather a lot more of that information once you become patent pending. Now let's talk just for a minute about claim scope. I don't want to get into this too much because we're not going to be drafting claims in this module, but this aligns really well with the claim scope or the breadth and narrowness issue that we've been talking about. And I want to introduce a couple concepts to you. Again, just for reference, if this feels overwhelming at all, skip this module and go on to the next one, and we'll get into drafting your detailed description. That's not a problem if this context doesn't feel like it's useful. In this diagram, it's just a simple Venn diagram. I've got different colored circles. Some of them overlap a little bit. Some of them overlap a lot more. In the green circle, it's what I would consider to be prior art. It's the stuff that already exists out there before your invention exists. In the blue circle, we've got prior art again, although this is in quotes. This prior art refers to the fact that you might admit certain things are prior art. And in some instances, you might make an admission as to something that you believe is prior art outside of the green circle, when in fact it's not. So be careful about what you're admitting as to prior art. We've talked about that already. Then you've got your innovation. That's what I would consider to be the breadth of your patent that you're trying to get. You've created this general innovative concept. It might be a lot broader than the actual product you're making, and that's fine. To the extent that it overlaps, though, with prior art or with admitted prior art, you're going to run into trouble trying to get your invention patented. That's the patentability issue, the too broad issue that we talked about previously. To the extent that your innovation falls outside of the prior art or the admitted prior art, that's where you'll want to focus your attention in trying to get a patent on that scope. And then to some degree, you'll have a product that you create perhaps, and when you do create a product, hopefully that product is completely covered by your innovation. Now, some of that product might incorporate prior art technologies, and some of it might be entirely new technologies that you've created as part of your innovation, and that's just fine. Think about how these different layers might overlap. If you want, you can even take a piece of paper and draw some circles around it, and you might find yourself drawing a circle that says, oh, I've got a product and I've got an innovation somewhere, and they don't overlap at all. You could see the obvious misalignment in that scenario. But you might be surprised that in the patent process that can happen. Sometimes miscommunication with a patent attorney and the inventor can lead to a misalignment as to what's actually being protected by the patent versus what the product is. Sometimes it's the product itself that moves. As the product is being developed, it might go through changes or revisions that move it further away from what is described and claimed in a patent application. And that happens too. And so you'll want to be aware as those different circles move relative to one another, they either align or misalign more or less throughout the course of the patent process. This is just one way to think about some of the different, again, balancing factors that you might want to consider as you're drafting your patent application or as you're in the future working with a patent attorney to help draft a non-provisional patent application and the claims. Here's another way to look at your patent application, and I call this a patent productivity diagram. This is where you have really three aspects and you want to know how well you're aligned on these. And I think that the more you're aligned on these, the better off you are, the more valuable your patent is, the more valuable your product is. You can play with these and see what you think. To some degree, everybody comes up with an idea. They've got these technical specifications they're working on as to actually how they would build their product, what it is that they've invented. Then you've got your patent specification. That's where you're describing in a legal document what your invention is. You might be able to see how, or maybe you've seen, how some patents and patent applications in the past don't really describe the same thing in the patent specifications as what a technical team has come up with in their research and design process. To the extent that those don't align, you've got misalignment in your patent portfolio and you've got a less productive patent portfolio. There's also a possibility that the patent specification might be different from what the patent claims are. Usually there's quite a bit of alignment up front as to what those are, but you'll find that when a patent is examined, the patent examiner will introduce different perspectives than maybe what the patent drafter or the inventor had thought about. And they'll take those perspectives and they'll start making assertions as to what the claims mean, when at first blush it will appear that the examiner is completely misaligned with what your invention really is and is mischaracterizing it, but you might find upon further review that they actually have perhaps a reasonable basis for the type of interpretation they're making, and you need to clarify what your claims say so that you can stay in alignment with your patent specification. Anyway, this is just one way to think about how productive is your patent portfolio. You might only have one patent application pending, or you might have a few or many, and that's just fine. But think about where the differences are, or where the differences might come into play between what you put together as your technical specifications versus what your patent specification says versus what your claims say. This is, again, getting into a lot more detail than you need for a provisional patent application, because we're really just dealing at this stage with a patent specification. Even if we put a couple claims in there, the claims are actually considered part of the specification and description at the provisional stage, rather than the legal description and definition of the scope of the invention. This is just some food for thought as you go through this process, thinking about all of the different things that you can keep in balance or perhaps get unbalanced throughout the process. Lastly, this is just a colored diagram, more detailed, of the last patent productivity diagram we looked at. And I don't want to talk about it in a lot of detail, but just introduce the fact that the green area would be where your portfolio is most productive, because your claims, your patent specification, and your technical specs are all in alignment. The blue area is where you have opportunities, at least from a patent perspective, to gain some ground, perhaps broaden your protection beyond what the claims in your patent application say, beyond what the technical specifications say. This is where you start to think, how do I increase the scope of protection I have against competitors potentially coming into the market? A lot of that comes from the patent specification. This is why in the provisional patent application stage that you're in right now, it's important to put in a lot of examples into your description so that you show that you've got opportunities to expand your protection in the future if you need to do that. And then all the red areas here are waste, at least from a patent sense. Your technical specs might be outside of your patent scope simply because you're dealing with technologies that are more conventional and you can't protect with patents. That's not necessarily a bad thing from a business perspective. From a patent perspective, it does put you at risk because you can't necessarily protect your invention from other competitors in that space. But it's not necessarily a negative to your patent or your invention. It's simply a realization that you can't protect things that are already known in the public. However, the areas of the patent claim circle that are in the red really present an area of risk because you've tried to claim or assert protection for certain things that fall outside of what your patent specification supports. That becomes a problem. It sometimes happens when you get in the middle of an examination process and you start to claim things in a different way that are a little bit less like what you've described in your patent application. You might feel like you're pushed into that by a patent examiner who's got the funky interpretation that they're imposing on you. But nevertheless, anytime you get outside of the patent specification and outside of your technical specs, you're going to run into issues and potential problems of invalidity or simply waste in the patent application process. And waste in the patent application process adds up really quickly when you're paying expensive attorneys, you're paying government filing fees, you're filing in multiple countries. You just want to limit the waste as much as you can in this process. So that's it. You should now be able to anticipate and differentiate a little bit more than before between patentability and enforceability issues for your own provisional patent application.